Proceedings are resumed. Madam Clerk, the next item of business, please.
Private Member Motion Number 10 of 2014-15, Amendment to the Labor Law 2011 Revision, to be moved by the elected member for East End and seconded by the elected member for Northside.
I recognize the member from East End.
Thank you, Madam Speaker. Madam Speaker, I beg to move Private Member's Motion Number 10, standing in my name, which reads, whereas the Cayman Islands have been subject to the global recession since 2008, and whereas the unemployment rate has risen steadily since 2008, and whereas the labor law is expected to provide protection for the labor force, and whereas it has long been recognized that the provisions of the labor law are inadequate to protect Caymanians from unscrupulous employers, and whereas the government has indicated that it will bring amendments to the labor law to the Legislative Assembly, and whereas there have been numerous complaints by Caymanian employees of employers releasing them from their employ under the guise of downsizing due to economic hardship, and whereas employees being released other than in accordance with the redundancy provisions of the labor law are being paid severance pay of 1 week wages per year of employment and given an additional week wages per year of employment as gratis pay, and whereas many employers are being advised that if they pay said severance pay and a gratis, it can be considered an unfair dismissal pay award in accordance with the labor law if employees challenge their dismissal. And whereas employers are applying for work permits to fill the positions previously held by Caymanians improperly dismissed on grounds of redundancy, and whereas the National Workforce Development Agency and the relevant immigration boards are never made aware of the tactics being used by employers and continue to issue work permits, be it therefore resolved that the government consider amending the labor law to require employers who claim downsizing through redundancy of Caymanian employees where foreign work permit holders are employed to prove such redundancy to the Labor Department and notify the relevant immigration boards. And be it further resolved that the government consider increasing the amount of award by a labor tribunal for unfair dismissal to an amount equal to up to 3 years' wages at the employee's latest basic salary at the day of dismissal.
Is there a seconder?
Yes, Madam Speaker, I beg to second the motion.
The motion has been duly moved. It is now open for debate. Does the member from Easton wish to speak there at all?
Thank you, Madam Speaker. Madam Speaker, I've been here long enough to understand that you should not measure your success in here based on what immediately preceded you. So I approach with caution. And what I do know, Madam Speaker, is that the motion that preceded this was about protection of us all, hopefully. And that will get the kudos of the members, for the members of this parliament, this legislature. What this one will bring for us is that we will be, or at least me, I will capture a space in the annals of the editorial, following on with what has been going on all week. Because every time we bring something that helps or protects our own people, we are, no. I I didn't want to use such strong word, but Madam Speaker, we are taken to task. I think is the right way to say it. Madam Speaker, let me begin this presentation by saying that this motion is in no way brought here to embarrass the government. Madam Speaker, I am very aware, as I said in this motion, that the government is bringing some, whether it's amendment or total repeal or whatever, to the labor law. Now, as to when that is coming, I don't know. But the circumstances are such, Madam Speaker, this thing has gotten so far out of hand that I want to impress upon the government one of two things. One, if the labor law repeal or whether we're going to repeal it or we're going to amend it is coming in short order, I would like these things included therein. That is my proposal. And if that is not forthcoming in short order, I would impress upon the government to bring some kind of amendment to the law, because it shouldn't take very much to do it, to put it as a stopgap until we can get to the substantive amendments or the repeal. Or the revision, well, not revision, but it's got to be a repeal or it's amendments to the law. Madam Speaker, I know the Premier said vilified. Maybe we will be vilified for this. But, you know, sometimes you have to do what you have to do. And one of the things I believe the fourth elected member from Bordentown said is that it's obvious that when it comes to issues of our people, we are united. Some people who come to this country don't understand its history. So let me enlighten them a little bit about how EastEnders used to work. You hit one, you got hit all. Because whilst we talk about the editorial, talking about it in search of a united Cayman, Madam Speaker, I'm the last one to come to the Premier's aid because I know where he come from. And I know he is very capable of defending himself, or for that matter, the Minister for Finance. But the only lack of unity in this country happens to be perpetrated by the editorial board of the Cayman Compass. And today, I am of the view, personal opinion, that director or editor, whatever they call them, or owner, is a plan in this country to destabilize it. And it is the responsibility of the powers that be to find out what he is, what he's doing here, and why he's going on the way he's going on. He's talking about the uniting Cayman. He is the one who's splitting up the Caymanians. And the last time, Madam Speaker, I saw somebody conducting themselves in this manner was when we had to chase Gibbs and the Attorney General out of this country. And we know they were MI6. That is a proven fact. This one comes from America. I need to know if he's the other side of MI6 in America. CIA with the intent to destabilize my country. And I know he buys the ink by the 45-gallon drum. He got plenty to buy. He likes to say that the premier shouldn't say that those communists shouldn't say that they tell us what to do and what have you. And then he talks about, you know, about those that came. He has no point or reference for this country. He needs to go back in the history of this country and the history of those that he would name in his paper and understand that it's only in the evening of life that they received atonement for the sins they visited upon my people. Especially South Sound. He like driving along that road now? He may very well be living there. Let me enlighten him. It was a swamp. Ask him who filled it in and made millions off of it. The same ones that they are revering, same ones they're revering right now and brought so much to us because we were just seamen. You know what I told Prince of Edinburgh? The Queen husband, what he named now? Duke of Edinburgh. He said to me while standing next to Desmond Tutu. He said to Desmond Tutu, he said, oh, you know, Cayman only export at one time were seamen, writing 10 down in house. And I looked at him and I said, yeah. And they were so good that they built the country and your people are all there now. Yeah, man. Loaded, I'm loading you up too. That's how it works. Madam Speaker, you see, somebody told me one time that we create our own enemies. And that we have. We create our own enemies. Our own dragons that spit fire at us and consume us in their fire. That man is the same one. Talk about there's nobody that can talk about. Madam Speaker, just give me one break. You have made me read this. He says the Premier averred that a Caymanian who strives, who wishes to work, who does what is necessary to get the qualifications and the training should not be passed over for a job opportunity in favor of a non-Caymanian. Not only do we agree with that position, we aren't aware of anyone, expat or Caymanian, who has ever argued seriously to the contrary. He lied. Here's the man who told that same premier that's a shame that only Caymanians run this country. He should have told me so. He better be glad it was him he told. of course, I was not very pleased with the Premier, who was Minister of Education at the time, that he didn't tell me in his presence what he had said. That's who we have in this country. Then we go and give him status. Who you think would do that? Madam Speaker, I have been here long enough to understand and he should take note. And I know there's going to be a big headline tomorrow. I hope he's listening good, because it doesn't bother me one iota. I always get Fridays. Madam Speaker, there is no prerequisite to enter these halls. The people of East End chose me to represent them. Whilst they were doing that, they extended to me the privilege of standing on this floor and defending them without possibility of prosecution. Every time he comes with these editorials trying to split this country up, I go at him from this floor.
I know that you're very passionate, and I've noticed that you're not laboring to make your deliberation, but could you meander back to the motion fairly soon?
Well, Madam Speaker, I will bow to your wishes and your ruling. But he meandering all over the place too, you know, and try and kill us too. Madam Speaker, he see him one causing labor problem. If you want me to go back to labor. Madam Speaker, the fact that people like him can get out there and beat us as legislators means that his friends, or maybe him, I don't know what his practices are in his company, or his supposedly company. I don't know what his practices are, but that is why we are here with this same labor thing. Because of attitudes like this, they all think they have us by the short and curlies. But Madam Speaker, we all Madam Speaker, I know the Premier can say that I shouldn't do this, but Madam Speaker, in my last lick on him, I invite him to read the lyrics from the Eagles song, The Last Resort. And that's where we are now. And I would draw particular attention to the verse which says, who will provide the great design, the grand design? What is yours and what is mine? Because there is no more new frontier. We are ready about away with a piece of land, even though the minister out there don't think so. We have got to make it here. I want to draw that to his attention. We got to make it, or we got to break it. And anything I do in advocating on behalf of my people, I make no apologies for it. I want him to understand that. So he can write, I hope he got 45-gallon drum beat tonight. Thank you, Madam Speaker. I need to get that one off my chest. Madam Speaker, I know. I was mindful a few weeks ago when I occupied the front page to put in a motion on for the government to assist me with calling for an amendment to the law to require all newspapers to publicly display their beneficial ownership. But we got to get to that one, because we need to know whose interest is being served. I know who my masters are. They have in East End. I want to know who their masters are. All of them. Oh, for God's sake, hush about that one. No, Madam Speaker, I get very passionate when it comes to the people that I love. But they look like they're trying, and with this labor as well, Madam Speaker, look like they're putting barbed wire up and they're corralling the Indians on the Great Plains. That's what they're trying to do us. They want to be in East End. All they can do on one down, yeah. He want them that got them spurs on a heel, or we got to burn them off. We got to take them off there. Madam Speaker, let me get back to the motion. Please, Madam Speaker. Madam Speaker, I believe this started with us in the recession. And Madam Speaker, I recognize that the Minister of Finance made a statement recently, and he said that things are starting to show signs of a comeback. And I believe between 2013-14, he said that the unemployment rate of Caymanians declined by 9.4% from the 10.5% in 2012. He also went on to say that, in contrast, the unemployment among non-Caymanians increased by 23%, resulting in an unemployment rate of 3.1. Now, somebody need to tell me how non-Caymanians in this country on the unemployment list. But we'll have find out from the statistic ESO on that particular thing. Anyway, Madam Speaker, I am happy to know that, and I did put in here that it has risen steadily since 2008, which is true, because in 2008, just before the recession, I believe we were 5 or 4 point something percent unemployment rate. But now that it's begun to contract, that is welcome news. Madam Speaker, we know the labor law is, the purpose of the labor law is to protect the labor force, whether it's Caymanians or those who are working here as visitors. For years, we have recognized that labor law, the provisions in the labor law, just does not do the job that it is required to do. And keeping with that, in 2000, I think it was 2004, the new employment law came into, was passed and never put in force. And 2 governments since then, one included me, did not do anything about it. So I'm not trying to embarrass anybody. What I'm saying is the time has come for us to step up, because the only persons who are being or the majority of the people being disenfranchised because of the lack of proper provisions just happens to be Caymanians. Madam Speaker, very little has been done to the labor law since its was brought in force, which was 1987. And very little major changes were ever put in place to enhance that law. If it had gotten as much as the immigration, we might have gotten something right, but then we got that all wrong too. So, but Madam Speaker, one of the things under the labor law is that the existing penalties do not provide deterrent for employers to comply with the labor law. And some of the rookies over on that side talked about those penalties the other day. I think it was the fifth elected member from Georgetown, that they circumvent the law, and there is no, the penalties are insufficient to even deter them, much less stop them. Madam Speaker, in doing my research for this motion, I happened to have a friend who lives in the Turks, and he indicated that I should look at their labor ordinance, I think it is. And it was very instructive, Madam Speaker, and I would encourage all members of this honorable House to have a look at it. It is superior to our law. It is it has extreme protections for the people of the Turks and Caicos Islands, the belongers. Madam Speaker, and I don't want to read all of it, but all provisions for redundancy, and yes, Madam Speaker, we have similar provisions we have provisions for redundancy in our law, but there's some that is very, very, very pointed. For instance, where the reason or principal reason for the dismissal of an employee was that he was redundant, but it is shown that the circumstances constituting the redundancy applied equally to one or more other employees in the same undertaking who held positions similar to that held by him and who have not been dismissed by the employer, and either A, that the reason, or if more than one, the principal reason for which he was selected for dismissal was one of those specified in subsection 1 of 70, or that he was selected for dismissal in contravention of a customary arrangement or agreement procedure relating to redundancy, and there were no special reasons justifying a departure from that arrangement or procedure in his case, then for the purposes of this part, the dismissal shall be regarded as unfair. Madam Speaker, our redundancy doesn't even go that far, but the tribunal that they have there as well has wide sweeping powers. Here, a tribunal can inquire into it, but they are only allowed to award up to 1 week for every year the employer had been on the job. Madam Speaker, in the remedies for unfair dismissal, the employer better know what they're doing down there. if the employee's complaint of unfair dismissal is found to be proven to the satisfaction of the labor tribunal hearing the matter, it shall award the employee one or more of the following remedies. A, an order for reinstatement, whereby the employee is to be treated in all respects as if he or she had never been dismissed. B, an order for re-engagement, whereby the employee is to be engaged in work comparable to that in which he or she was engaged prior to his or her dismissal, or other reasonable, suitable work from such date and on such terms of employment as may be specified in the order or agreed by the parties. An award of compensation as specified in subsection 4. D, or other such remedies as the tribunal may order. Subsection 4 says, an award of compensation shall be such amount as the said labor tribunal considers just and equitable in all the circumstances having regard to the loss sustained by the employee in consequence of the dismissal, insofar as that loss is attributable to action taken by the employer and the extent, if any, to which the employer caused or contributed to the dismissal. The amount awarded shall not be less than 2 weeks' pay for each year of service for workers with less than 2 years service, and 1 month pay for each year of service for workers with more than 2 years of service of seniority. An additional amount to such loss should be awarded where the dismissal was based on any of the reason under subsection 2, which is contrary to reinstatement, if it was reinstatement. Where on a complaint under subsection 83, which is that one, the tribunal finds that the grounds of complaint are well-founded, it shall explain to the complainant what orders for reinstatement or re-engagement may be made under section 88, and in that circumstance they may be made, and shall ask the complainant whether he wishes the tribunal to make such an order. And if the complainant does express such a wish, and the tribunal may make an order under section 86. If on a complaint under section 83, the tribunal hearing the complaint finds that the grounds of the complaint were well-founded and no orders made under 86, the tribunal may make an award of compensation for unfair dismissal calculated based on those over there that I just read. Madam Speaker, just getting into the amount of compensation, and it's extremely lengthy, Madam Speaker, and I don't want to bore the House with all this. But if an order under 86 is made and the complainant is reinstated, or as the case may be, re-engaged, but the terms of the order are not fully complied with, then, subject to section 92, the tribunal shall make an award of compensation to be paid by the employer to the employee of such amount as the tribunal thinks fit, having regard to the loss sustained by the complainant in consequence of the failure to comply fully with the terms of that order. Except in a case where the employer satisfied the tribunal that is not practicable to comply with the order, the tribunal may make an additional award of compensation to be paid by the employer to the employee in an amount not less than 13 nor more than 26 weeks' pay. Madam Speaker, as it goes on, if the amount of any payment made by the employer to the employee on the grounds that the dismissal was for reason of redundancy exceeds the amount of the basic award which would be payable but for subsection 6 of section 90, which I read, that excess shall go to reduce the amount of the compensatory award. 92, the amount of compensation awarded to a person under subsection 1 of Section 88 or of a compensatory award to a person calculated in accordance with Section 91 shall not exceed $35,000. Madam Speaker, I read all that to say that this tribunal, its findings, its orders cannot even be looked into by a law, by a court, a higher court, unless it's on point of law. That's the kind of power they have given their tribunal. No, Madam Speaker, that's what I'm trying to impress upon the government. We need to put something in place to deter these people from firing Caymanians. Madam Speaker, I ain't talking about firing for cause, because the provisions are in our law for that. If you're gross misconduct, hey, nobody in this world can save you from that, or other matters as well. But when it is proven that it's for unfair dismissal, then someone must pay that Caymanian. Madam Speaker, I must say that I had my own troubles recently in my own constituency. But, Madam Speaker, since then, I have received representation from at least 5 people who are not constituents. The most recent was last week, Tuesday. As the member from Northside and I got off the radio, there was a gentleman outside who had just been dismissed by Ritz-Carlton for nothing, according to him. Of course, Madam Speaker, I never went into any detail. I didn't do any research or anything of that matter, because he said it was with the Labor Department. Madam Speaker, it cannot be. No, let me put it this way, Madam Speaker. I know every member of this honorable House, including your good self, Madam Speaker, has had representation on that same thing. There's not one that can hold their hands up and say that they have not had representation over the last year about these people letting Caymanians go on the basis of redundancy. Now we got to do something about it. And I rushing the government. I want them to deal with it in a timely fashion. Madam Speaker, during June, I was inundated with complaints from my constituents who are working at an establishment in East End, namely Tortuga Club. Madam Speaker, there comes a time when you have to do what you have to do to defend your people. And I know there are consequences for everything I do, Madam Speaker. I can't control the consequences. I can control the actions. But my own actions are honorable. My actions are noble in this cause. Madam Speaker, I went and got a gallon of ink as well. And I wrote the authorities that be, who just happens to be the minister. And I wrote the minister in July, and I said, "Dear Minister, re Morris Tortuga." And I'm going to call it out because it's time, you know, what you got to do? I've had enough of it. I write in relation to several issues at Morris Tortuga that have come to my attention through representation by the Caymanian staff. Over the last month, I have received numerous complaints of unfair employment practices being carried out by owners and management of the captioned establishment, namely, 1, an employee, Mrs. Janet Browning, of 25 years, dismissed apparently without reason with claims of position redundancy. 2, accusations of the restaurant manager, Mike Finnerty, mistreating employees and making up unsubstantiated reports to the owner, David Morit, which results in the dismissal of Caymanian staff members. 3, claims of the owner preparing to dismiss 20-plus Caymanian employees and interns. 4, the approval of a temporary work permit for Chris Johnson, the son-in-law of the owner of as the operation manager while a Caymanian, William Conley, was in post. On Tuesday, 8th of July, I met with Mr. David Morit, Chris Johnson, and Mike Finnerty with the hopes of assisting where possible to calm the situation by informing them of the complaints received. To my amazement, I was informed that William Conley was terminated the previous day and that the human resource manager, Joanne Watler, had resigned just hours prior to my arrival. In the case of Conley, he was being accused of hiring family members and rehiring former employees who were dismissed for drinking on the job. Mr. Johnson accused management prior to his arrival of overstaffing the establishment and not addressing discipline matters reported by managers, and such as drinking and sleeping on the job. As a result, it was decided to reduce the staff complement in line with the pre-Ivan levels based on staff per unit ratio. When told that he must have documented evidence to dismiss, he indicated that he was new to the job and had been advised that he only needed to pay severance pay and unfair dismissal. He was advised to consult with the labor office prior to proceeding. Based on the number of complaints and this admission of Chris Johnson, it is apparent that there is more than meets the eye at this establishment. There are many unanswered questions, such as, why was an employee of 25 years terminated without documented evidence of any wrongdoing? What are the circumstances surrounding the issuance of a work permit to Chris Johnson, who has no previous hotel management experience while the Caymanian was in post? On what basis are 20-plus Caymanians' jobs being terminated? If Mr. Johnson's admission can be believed, we are facing a potential problem with Caymanians being terminated without cause and the labor law provisions being inadequate to prevent such abuse and not protecting the Caymanian workforce. Subsequent to my meeting, I have continued to receive concerns from the Caymanian staff. Some have been released. Mr. Finnerty appears to be manufacturing reason to discipline staff, which resembles constructive dismissal. In addition, he's applying for a work permit for a current work permit holder to be shared with another company, DART. It seems rather disrespectful to downsize by releasing Caymanians and applying for another work permit during that process. This practice seems to be the order of the day, and immigration is none the wiser or lacks the investigative processes to address the antics being used to disenfranchise Caymanians. Your kind attention to this matter is appreciated. If I can be of further assistance to this process, please let me know using the contact details provided. Madam Speaker, the minister got back to me and it was being dealt with by the Labor Department. So, I put pen to paper again, and I went to every member on the business staff and board, chairman, everybody. Dear sir, Morris Tortuga Club, Attached, please find a letter sent to the Minister of Labor recently concerning labor matters at Morris Tortuga. As a result of my letter and other complaints to the Labor Department by former and current staff members, the department has conducted a number of inspections of the premises. Follow-up with the department staff has revealed that they have given Mr. Chris Johnson written warnings of infringements of the labor law. Additionally, the Immigration Department has been informed of the Labor Department's findings. Like my concerns expressed to the Minister of Labor, I believe there are a number of areas that your board and your good self should pay particular attention to. Namely, how could a temporary work permit be granted for Mr. Chris Johnson while an experienced Caymanian was in post? Additionally, Mr. Johnson has no previous experience as per Section 44 of the Immigration Law 2013 revision. While Mr. Johnson claims to be downsizing the staff, complement for economic reasons, on what basis is he applying for a shared work permit for one Ramesses Mariana? In the matter of Mrs. Janet Brown, an employee of 25 years, why was she apparently terminated without reason? And who will be replacing her? Who will she be replaced with on the business staffing plan? Does Mrs. Mimi Morit possess a work permit, and what is her position at the establishment? While I appreciate the Tortuga establishment has stood the test of time in the District of East End, not only as a responsible corporate citizen, but as a favored employer, I nevertheless question the objective and management practices of late. There appears to be a deliberate attempt to release the Caymanian staff and replace them with foreign nationals while circumventing the provisions of the labor and immigration laws. Over the last month, at least 2 other instances of similar situation have come to my attention wherein employers are apparently deliberately releasing Caymanian employees on the basis of redundancy. These actions must be treated with the utmost attention and addressed with immediate dispatch. As such, it is my intention to bring this matter to the attention of the government through the legislative process. Now, Madam Speaker, I know I'm going to be vilified for reading all that out, but I'm okay with that. I don't have a problem with that, Madam Speaker. If I leave it and allow it to fester, more and more Caymanians are going to be sitting on the sidelines. It needs to be addressed. It is important that these things be addressed. Madam Speaker, I believe that we have a perfect opportunity here to send a message to all those who would otherwise treat Caymanians with absolute disdain. Madam Speaker, they tell us that we needed education, then they tell us we needed experience. How much more experience do you need than 25 years on the job? Madam Speaker, this is not putting together the shuttle, you know. This is a banquet manager or events manager or something of that nature. 25 years. Not one disciplinary complaint on this lady's file in 25 years. Built the establishment. And just out of the clear blue sky? Because we bring in some foreigner to take over? What are we doing? Where are we going? We are worse off today than we were 40, 50 years ago. Yes, Mr. Lega, we went to sea, but those who were left behind built this country to what it is today. Madam Speaker, at least we were working. We had the third elected member from West Bay Mother down at Galleon as a waiter. We had Anna Martin bartender. We had our painters. We had everybody who was working. Here we are. Madam Speaker, it can't be. It cannot be. It's impossible for me to understand how Caymanians could get so dumb in a matter of 10, 15 years. 20 years. You mean tell me we didn't do anything? Madam Speaker, it's not that. It is too much friends they bring in to take the place of Caymanians. Those who get here, they bring their friends. Those who spy on us, they bring their friends and their family. And we are shortchanged in our own country. Madam Speaker, I want it to be known that I have lived through some tough times in this your country. Long before all of them come out Jordan and in New York, from the papers up New York and all that. Okay? I have seen it. Much of it is of distant memory. But I have seen enough to know that when the bubble bursts, what is going to happen? We are skating on thin ice, and it's going, I hear it cracking. Madam Speaker, I hear it cracking. If we don't address these matters, we are going to have problems. We talk about bringing motions on taking money from the work permit. I want everybody to understand that does not take away from those Caymanians in the workplace. Now they're not going to throw them on top the Minister of Education with her programs with that little $7 million. They have a responsibility to train them on the job. But that's what they want to do. And yes, the second elected member from Georgetown, he looking at me. I know he got friends that are eager to jump on that accreditation thing. And I want to see that, and I support that. But they must understand, we are not letting them off the hook. Whether the carrot got honey or brown sugar on it, it is not going to happen. We cannot afford to do it. Yeah, and then they say they don't have an obligation. You gain the work permit with those conditions on it. You understood what they were. But what they're doing, Madam Speaker, is you notice they don't have trained anyone on work permit. It doesn't say that, you know. So it's easier for them to hire someone on work permit. I want to know how. And Madam Speaker, I really need to sit down because everybody don't get the gist of this, but it aggravates me. Huh? Immigration law. Oh, the nights I stay up, try to understand these things. the Work Permit Board, the Business Staff and Plan Board, or the Chief Immigration Officer, as the case may be, in considering an application under Section 42, which, Madam Speaker, is in this part, unless the context otherwise requires a reference to the Chief Immigration Officer in relation to the grant or renewal work permit, shall be construed as including a reference to anyone specifically designated by him to perform those duties. Shall, in respect of an application for a grant, or may, in respect of an application for a renewal, remember now this was a grant I'm talking about, subject to any general directions which the governor may, from time to time, give in respect of the consideration of such application, take into account the matter listed in subsection 2 to 4 in relation to the prospective employer that he has demonstrated his genuine need to engage the services of the prospective worker. He has, unless he has been exempt from the governor, by the governor or by the board, sought by advertisement on at least 2 issues for 2 consecutive weeks in a local newspaper to ascertain the availability of any or more of the following in the order of which they are listed. 1, Caymanian. 2, the spouse of Caymanian. 3, the holder of a residence and employment rights certificate. 4, a person legal and ordinary resident in the island who is qualified and willing to fill the post. In the case of C, in the case of an applicant in respect of a professional, managerial, or skill occupation, the board or the chief immigration officer, as the case may be, is satisfied as to the extent to which he has established adequate training or scholarship programs for Caymanians. And in the case of a worker who has a term limit of 10 years under Section 552(1), the extent to which the employer has contributed to the National Training Initiative. This thing is littered with it about training, you know. 3, in relation to the worker, A, his character, reputation, and health, and where relevant, the character, reputation, and health of his dependents. B, his professional and training qualification, and his experience and competence to undertake the position applied for. So how are you doing with somebody up there as operation manager that never see hotel room in his life? What are we doing? Is this what our country has become? Madam Speaker, I'm ready and willing to work with the government to stop this abuse. We need to stop the deliberate destruction of our people. Madam Speaker, yeah, Madam Speaker, that's true. It's psychological warfare. And the only one losing is us. And the ink on this is the other psychological. This is not psychological. This one you're direct. This one you're direct, Madam Speaker. I need to tell him. I need to send him a message. You're not part, we. Okay? We are we. He not part we. He don't deserve to be part of we. Me and you, that buckle go with Toya, he don't deserve it. If it, you know, honestly, man. Madam Speaker, let me politically go at the premier come at me. The government come at me, I go at them. That's what this debate is about. Let all Roy Bodden think all and sundry. No. That when you touch one in here, you're touching all a we. As soon as we come up with something to try to help our people, boy, we're causing division. Causing division? Should have been back then. Madam Speaker, you know, I thought it was necessary for me to read these letters, not to embarrass the government, nor the minister that I wrote the letter to, nor the immigration people, because they have been in contact with me and they're working on it. No. Madam Speaker, there are provisions in this immigration law which prevents the boards or the chief immigration officer from issuing a work permit by law, particularly if they're not qualified. Madam Speaker, I was told that Mr. Johnson, who is not qualified to hold that position, got a temporary work permit. Ended up the end of September. I trust we got to see his back. Because we can't permanently give him a work permit when a Caymanian is available and willing to do it. We need to stop it. And the restaurant manager too. He must bid his staff goodbye. Madam Speaker, you see, poor old Benson, he said we like to wear our hearts on our sleeve. And we do that so often. We would not be in this mess. This kind of mess. If we had reserved the right to come to your house and pick you up in the middle of the night, and you must know that you're gone, your full suit, not no pajamas, how we putting you on the plane and carrying you out. We must reserve that right, Madam Speaker. But he's right in his editorial. Some of the division is among us as Caymanians. Because we have sold of a very soul for the almighty grain. Some of us. We don't venture into the areas where our people are not doing so good because we don't want to be seen there, you know. That's not our place be. So we stay in our ivory towers and we support those in other ivory towers, not giving any concern, any account of those who the fifth elected member from Georgetown is trying to make provision for, and the sixth elected member is trying to ensure that they don't go in our house. And the member from Northside. Many of us are not concerned about them. But when they visit our doorsteps, then we start crying. And then when they hear legislators putting something in place to say 10 years, we applaud legislators. But then as soon as we force them in the law to adhere to the provisions of keeping the Caymanians on the job and giving them opportunity, so that they can survive in their own country, we are vilified. That's what they do us. And we sit down here and roll over. Good thing this country now run by one person. I promise you that. I'm glad, Madam Speaker, we are living in a live and vibrant democracy. It's wrong. Each one of us have had to put our hands in our pockets to help our constituents. Are you ashamed of it? Why? Because they just got terminated. Why were you terminated? No reason, Mr. Arden. I don't know. You think that's fair? And you think that's fair to our people? And the premier is coming looking, what is 70 million for your social services? And you think that's fair? Madam Speaker, how can we allow these people to arbitrarily destroy our people? And Madam Speaker, the reason I say 3 years, you know. And now looking at Turks and Caicos one, I must tell you, I want to make an amendment, yeah, and leave it wide open. Madam Speaker, my thoughts were, though, that you terminate someone at 3 years before retirement. He has no place to go. Nobody can take no chances with him. If it's 5 years, somebody may say, let's take him or her for 5 years and get the experience that they have gained over those years. 3 years? You are a lone wolf out in a desert, the Mahaba Desert. You're done. They must pay for it. And if the government is so mindful, I made enough noise at them, they're not going to be mindful even respond to me. But if they are so mindful to accept this, maybe they want to change it and put it more. If they are so mindful to consider these things, I know they're being considered. Maybe the 3 years wasn't, they were looking at something else. But now that we have the benefit of not having to reinvent the wheel, and we have another overseas territory that has more provisions for their people than we currently have, maybe we want to look at it and try and get a little closer in line with that. I don't know. We need to stop these people because their lawyers are advising them, Madam Speaker, that if they pay the severance pay, which is 1 week per year, for every year up to 12 years, can you imagine? That's the other one needs to change. No, I'm talking about 1 year. One week. 1 week. 1 week per year. And then you work your life making money for people, and they give you 1 week severance pay for your year over there. 20 years? There are provisions in there too, depending on the amount of years you were there. It steps up 1 month after 20 years and that kind of stuff. Madam Speaker, we need to give people more. We need to send a message to these people who would otherwise try to circumvent the law. They're doing it, lawyers are advising them to pay the severance. You know, you look at people like you don't believe them when they say, so that man tell me, he lawyers tell him so. And then pay them one additional week as gratis per year, so that if they challenge it, then the tribunal will say, well, our hands are tied. You don't get more than we can give you. Madam Speaker, day where we got here talking about the working in the best interest of our people? Oh, no. No. I mean, but you know what? Madam Speaker, God forbid that them same glass windows get broken by them same people, you know. We don't want to say it, but that's the practical part of this entire thing. And Madam Speaker, I must tell you, I never aspired to be anybody that stood in the middle. I take one side. Now I may be up front, but I take one side. And I already know which side that is, and I'm sure and nobody can be that foolish to think that I'm not taking the side that I represent in here. Madam Speaker, it doesn't matter to me whether you're from Timbuktu or wherever. If you are a Caymanian, I have to defend you. But I also have to protect Caymanians from some other Caymanians. I can't allow them to take advantage of the less fortunate. That's our job, to bring some balance, some equality in the governance of this country. And our people, the lives of our people. Madam Speaker, I got other things I could say, but I don't want to prolong this torture that I am given to my colleagues. So I await to see what the government says, and then we will go home for the weekend or whatever. But Madam Speaker, I implore the government. I can't say do it tomorrow. We can't do that. But at the very least, I know my bringing this, I have one already. If the government accepts it, Madam Speaker, I bet you won't see no redundancy starting tomorrow. Or they'll go out there and get rid of everybody. Madam Speaker, our Immigration Board and the NWDA needs to keep a closer watch on these people. They are fooling them. They are lying to them and go and give them all kinds of stories. And our people on those boards or in the departments, they in their efforts to try and support the businesses, they just do it. They must learn to be like Ronald Reagan, trust but verify. You cannot trust these people, many of them. I'm not saying that it's everybody. I would never say that. I would never be so bold. Because I know people, businesses in this country who don't do that. It's against their moral standards, their beliefs. But there are many others who will do it, who don't pay insurance, who don't pay pension. Then government, departments require some of my constituents, if they want go clean the civic center, they gotta get business license. And they gotta be in good standing. Can you believe that? For $500-600 a month? This won't be like America, you know. Madam Speaker, I submit my being to the government, and I hope that they find some peace in their heart to understand that this is for the betterment of our people. I may not have done it the way they wanted it to be presented, but I did my best.
Does any other member wish to speak? I recognize the Minister responsible for Labor.
Thank you, Madam Speaker. Madam Speaker, thank you. I'm just waiting for the lectern to be delivered. Madam Speaker, I rise to give the government's response to this very timely private member's motion brought by the Honourable Member from East End and seconded by the Honourable Member from Northside, which asks that the government consider amending the labour law to require employers who claim downsizing through redundancy by Caymanian employees where foreign work permits holders are employed to prove such redundancy to the Labour Department and notify the relevant immigration boards. And, Madam Speaker, to consider increasing the amount of the award of the Labour Tribunal for unfair dismissal to an amount equal to up to 3 years' wages at the employee's latest basic wage at the day of dismissal. Madam Speaker, possibly to the surprise of some in this chamber, I am happy to accept this motion to consider making changes to the relevant provisions in the labour law on behalf of the government, Madam Speaker. The government is happy to consider making those changes to those sections dealt with in this motion, namely that of redundancy and unfair dismissal. In fact, Madam Speaker, it is already being considered by the Ministry and the government, and discussions are well underway with the Legislative Drafting Department as to amendments related to the relevant provisions in the labour law to address the mischief that this motion seeks to address. Madam Speaker, as the member has rightly pointed out, or the members have pointed out in the recital to the motion, the government does indeed intend to bring amendments to the labour law to the Legislative Assembly in the near future, and the final amendments are being made to the proposed draft bill to amend the labour law prior to its submission to government for discussion and final approval, at which time a period of public consultation will ensue. Madam Speaker, the government is already convinced that the issues raised in this motion need to be addressed in relation to the proposed labour law reform, and we have already taken steps to try to address them in the draft bill. And in fact, Madam Speaker, the government's approach to addressing the issues will likely encompass to some degree what is being proposed here today. But, Madam Speaker, it will not be limited to the actions that the two honourable members are proposing in their motion. Madam Speaker, I thank the member for the very one important correction that he made in his delivery, which is that the unemployment rate of Caymanians has not steadily risen. Well, and namely, since we took office, we have seen a significant drop in the employment rate from 10.5% to 9.4% for Caymanians. And that, as he indicated, unemployment rate, thank you, it's late. The unemployment rate amongst Caymanians has dropped to 9.4%. And so that, coupled with the other economic indicators in the country, is signaling a positive outlook for the future. And so, Madam Speaker, before actually dealing with the aspects of this motion, I just wish to provide some background and context into some of the work that the Ministry and the Department of Labour have been carrying out for some time now on the comprehensive reforms to the labour law. Madam Speaker, for many months, the Ministry and the Department of Labour has been receiving solicited as well as unsolicited feedback from practitioners, from employees, from other stakeholders in the islands, including my fellow colleague from the District of East End. And we are now moving towards effecting priority amendments to address and intervene in emerging problematic areas, some of which are addressed in this motion today. Madam Speaker, the Labour Law 2011 revision, which is the current version in operation, as was indicated earlier by the member, was originally enacted in 1987. It has been amended on several occasions in order to address specific issues during that time, creating the 1989, 93, 95, 99, 2000, 2006, and 2007 versions. Madam Speaker, the most recent of these reviews happened in 2010 when the law was amended in order to facilitate compliance with the ILO Convention 182 on the worst forms of child labor, as well as to remove the years of service caps or limitations in relation to severance pay, retirement and resignation allowance, and the remedy for unfair dismissal, and the separation of the job placement functions from the department as part of the ministry's realignment of pensions and labor, which resulted in the 2011 consolidated revision. Madam Speaker, the last attempt for the comprehensive review of the labour law, as was indicated as well, was undertaken in the early part of the last decade, and it resulted in the Employment Law 2004. The commencement order was never issued to bring this law into force, however, Madam Speaker. But the Employment Law has been reviewed by the Ministry, and some relevant aspects will be taken forward in the draft bill to be considered by caucus and cabinet in the first instance, Madam Speaker. Madam Speaker, cabinet approved and the ministry issued initial drafting instructions to amend the labour law back in February and March of this year. However, Madam Speaker, I'm made to understand, due to limited resources and various legislative drafting priorities, the government is unable to bring forward a finalized discussion draft as yet. But, Madam Speaker, this is anticipated in short order. And I have once again impressed upon the Department of Labour and the Legislative Drafting Department the urgency of dealing with this matter. Madam Speaker, irrespective of the current economic conditions in these islands and globally, there are compelling arguments for reform and clarification of the labour law to benefit both the employee and the employer. Other progressive countries, Madam Speaker, are also carefully examining and amending their labour legislation, either despite or as a result of the current economic conditions. So, Madam Speaker, very briefly, the drafting instructions which frame the discussion draft for the bill to amend the labour law seeks to achieve the following objectives: to clarify several areas in the current law which cause operational and interpretation challenges for users, employers, and employees alike; to effect a number of housekeeping and tidying up, such as removing reference to the Department of Human Resources, etc. Also, Madam Speaker, the law will seek to, or the amendments to the law will seek to clarify and enhance the powers of the director in eligible cases where conciliation and mediation may allow those cases to be settled in-house rather than going to the volunteer-led tribunals. Madam Speaker, this should lead to a more efficient and timely disposition of some appropriate labour matters. Madam Speaker, most notably and relevant to this particular motion in hand is that the amended or the draft bill, will enhance the penalties and sanctions in areas which are now subject to sustained abuse, including unfair or unreasonable workplace practices, including unfair and constructive dismissal, and improper occupational safety and health practices. Madam Speaker, the revisions to the law will also look to generally align the labour law to the new vision of the Ministry and Department with respect to best practices awareness and specific standard operating procedures. Madam Speaker, so at present time, the drafting instructions reflect approximately 80 proposed amendments to the labour law, and there may be additional depending on the discussions and deliberations with Cabinet and caucus. Madam Speaker, during the past year, amongst the 956 inquiries and complaints received from aggrieved employees for various disputes, there were a total of 202 cases of terminations where compensation for severance and unfair dismissal were being sought. Many of those cases, Madam Speaker, approximately 80%, were resolved by the Department of Labour through bringing the disputing parties together and reaching fair and amicable settlements through informal conciliation and mediation. However, Madam Speaker, cases which could not be resolved through that process and where the complaint had merit, the matters were referred to the Labour Tribunal. And Madam Speaker, in those circumstances, if the complainant was successful at the Labour Tribunal hearing and where an appeal was not lodged by the opposing party, the tribunal could only award severance payment at a maximum of 1 week for every completed year of service, in accordance with Section 41 of the Labour Law, and where applicable, a maximum unfair dismissal award of 1 week for every completed or proportionate year of service, in accordance with Section 55 of the law. Madam Speaker, this private member's motion seems to be primarily seeking to address the mischief as it relates to terminating employees, particularly with respect to Caymanian employees, for reasons such as downsizing and redundancy due to economic hardships. And I may also add for other reasons such as globalization and regionalization. But failing to follow the rules for terminating on the grounds of redundancy, which is clearly outlined in Section 51(2) of the Labour Law. Madam Speaker, the other mischief for rectification identified in this motion involves the ability of employers who engage in these types of unreasonable and damaging practices to continue to obtain work permits, either grants or renewals, often for the same or similar type job that another employee, namely a Caymanian employee, was terminated from on the grounds of redundancy. Madam Speaker, there should be some form of reporting or proof requirement for employers to meet to justify these actions. This motion calls for it, and this is something that the government has already been considering when looking at making changes to the labour law. I may add, Madam Speaker, that due to the disparate multi-agency structure of labour and employment administration in these islands, namely the Department of Labour and Pensions being responsible for the regulation and enforcement and compliance aspects of the labour law, the Immigration Department being responsible for administering and regulating the foreign worker regime and enforcing the immigration law pertinent to such immigration or employment practices, and the NWDA being the main government vehicle for the training and development of the local workforce and the registration of job seekers. Madam Speaker, this type of interagency collaboration and connectivity may be somewhat of a challenge under the current regime. But, Madam Speaker, the government is committed to continuing to look at and improve the multi-agency culture of compliance. And we have made a significant step in that by connecting the avenue for job seekers, i.e. the National Workforce Development Agency, to the Immigration Department and its boards with respect to considering work permits. And Madam Speaker, as I discussed in my contributions yesterday on the motion with respect to the accreditation, program that was accepted by the government, I walked through some of the important employment-related provisions in the immigration law, as did the member from East End in his contribution. But there is one section, Madam Speaker, that I did not mention and that I think is worth discussing, because it is relevant not only to what this motion is seeking to achieve, but also in terms of what the government is seeking to achieve with respect to ensuring that the laws that currently exist are being enforced and that Caymanians are being given real opportunities to take advantage of the work and employment opportunities in the country. And that is Regulation 5 of the Immigration Regulations, which states where a Caymanian has applied for a position, the board shall, for the purpose of being satisfied of the matters specified in Sub-Regulation 1, take into account the following information supplied by the applicant for the grant of a work permit, namely the names of all applicants of the post, the qualifications, work experience, and background of all the applicants, the reasons given for the choice of the successful applicant and for refusal to employ the other applicants, a copy of the refusal letter and interview report for each unsuccessful Caymanian applicant, and a copy of the job description and resumes of the non-Caymanian applicants. And Madam Speaker, as a result of numerous complaints received and numerous complaints lodged both with the Immigration Department and with the National Workforce Development Agency about Caymanians applying to positions and their applications somehow ending up in file 13, the push was to create that nexus between the NWDA and immigration, so the immigration is aware of which Caymanians have applied for positions through the vehicle provided. And as the member from Bodden Town, the fourth elected member, said in his contributions yesterday with respect to the registration process, it may be time, Madam Speaker, for the government to seriously consider how to better improve the transparency of the job availability in the market by either having jobs go through or being registered or being posted with the NWDA. And I also would like to reiterate the call for having a transparent registry of positions as it relates to work permit holders or positions currently held by work permit holders, to give an indication of what jobs are coming to the market when. So we know exactly what jobs are available for persons who may be made redundant, for valid reasons, that may necessarily need to now find another position and transition into another position that may be coming available, which is not publicly or currently known given the current structure. So, Madam Speaker, getting back to the particular mischief at hand, the request for significantly increasing the award for unfair dismissal in this motion, it is asking the government to increase the award from 1 week's pay of the latest basic wage for each year of service with that employer to up to 3 years or 156 weeks' wages at the employee's latest basic wage at the day of dismissal. Madam Speaker, the movers have concluded that the law, or that these provisions in the labor law, are inadequate with respect to the 1 week pay. And Madam Speaker, the government agrees. This section, these sections of the law will be reviewed, and we will have amendments to address the issue of the inadequacy of the 1 week pay with respect to unfair dismissal and severance. Madam Speaker, by accepting the motion I would like to outline how the government intends to improve and strengthen the current legislative and institutional systems governing this aspect of labor administration in the islands, which I trust will enjoy the unanimous support of the Honourable House when the legislative package is introduced here, hopefully later this year. Madam Speaker, for the benefit of the honourable members and the general public, let me quote from the Labour Law 2011 revision on how Section 51(2) in relation to terminations on the grounds of redundancy is constructed. Where the reason for the dismissal of an employee was that he was redundant, but it is shown that the circumstances constituting the redundancy applied equally to one or more other employees in the same undertaking who were employed to perform work of the kind he was employed to do and who have not dismissed by the employer, and that those other employees do not hold the same status as the redundant employee for the purposes of Part 3 to 5 of the Immigration Law 2011 revision, Caymanian status, permanent residence, and work permits, and that the redundant employee was selected for dismissal in contravention of a customary arrangement or agreed procedure relating to redundancy, and there were no special reasons justifying a departure from that arrangement or procedure in his case, then, for the purposes of this part of the labor law, the dismissal shall be regarded as unfair. So, Madam Speaker, even though the current labor law contains a section which is clear about the basis for determining the fairness or unfairness of the action as it relates to redundancy, as well as the potential compensation, the problem exists, Madam Speaker, is that the Department of Labor and the other regulatory agencies have no prescribed means of collating and reporting the employment redundancy circumstances or cases that may exist. For example, Madam Speaker, what currently exists is that unless an employee makes a complaint to the Department of Labor for unfair dismissal under Section 51(2) redundancy, then the department would not otherwise know about it. So, Madam Speaker, at this junction, I would, however, like to commend those employers who do, in fact, consistently inform the department of cases of anticipated redundancies or terminations on other grounds, simply to get advice or to notify the department as a matter of best practice or common courtesy. However, Madam Speaker, whether the department is aware or not aware of a termination due to redundancy, the department's only remit under the current legislative regime is to take action under the labor law. Currently, there are no established protocols, and certainly, Madam Speaker, there are no powers in law for the Department of Labor to do anything more than inform other counterpart regulators, such as the NWDA and the Chief Immigration Officer, of the relevant cases of complaints and possibly the decisions with respect to labor tribunals and any relevant hearings. And Madam Speaker, the member from East End in his contributions confirm that in the particular case that he was dealing with, that has in fact happened, in that the Department of Labor has conducted investigations. They have weighed in on their interpretation of what is happening, and they have informed the relevant agency, in this case being the Immigration Department, of their findings. However, Madam Speaker, the actions of those other relevant agencies, such as the Immigration Department and the immigration boards, would be at their discretion within the parameters of the existing immigration laws and regulations. And as I said, Madam Speaker, there are provisions in the immigration law which would allow for them to act in these circumstances. Madam Speaker, the member has provided an example of another jurisdiction, namely that of the provisions found in the Turks and Caicos similar legislation, and I thank the member for that information, because as it will be left to the government to establish the administrative and institutional systems to implement the provisions of the amended or new labor legislation, Madam Speaker, the government commits to doing that prior to the enactment of any amendments to the labor law, which seeks to resolve the loopholes in the multi-agency enforcement of redundancies under Section 51(2) of the labor law. Firstly, Madam Speaker, we will have to establish the legislative framework and the procedures for determining what constitutes a breach of Section 51(2) of the labor law when this is amended. Additionally, Madam Speaker, we will have to operationalize these procedures by establishing a protocol or regime to require, one, the mandating of reporting of redundancies and all forms of employment terminations by employers to the Department of Labor, whether the employee files a complaint dispute or not. We would need to determine the appropriateness of specifying what type of information is required to be provided by the employers to the department in those circumstances. And Madam Speaker, we would need to establish the data sharing protocols with other independent regulatory service agencies, such as the Immigration Department or its boards. Madam Speaker, having conducted a brief legislative survey of how this issue is dealt with in other jurisdictions, the ministry has already begun to identify potential solutions to addressing the reporting requirements that would be necessary in order to effect the changes that both the motion speaks to and both the government is intending to bring forward with respect to redundancies. Madam Speaker, in some jurisdictions, redundancies which exceed a certain threshold number, say for example, employees in the case, 20 or more employees in the case of Ireland, in those instances, employers are required to report, and failure to report may lead to summary conviction of an offense and hefty fines. So, Madam Speaker, one of the things that the government will have to determine is the appropriate threshold in the context of the Cayman Islands employment regime. Madam Speaker, in addition, information about the plans for redundancy to be reported can include reasons for the plans of redundancy, the number and descriptions of employees it plans to make redundant, the total number of employees employed at the organization in question, how employees will be selected for redundancy, how and when redundancies will be made, taking into account any agreed procedure, how redundancies payments will be worked out, the effect on the contract and earnings where transfer or downgrading is accepted rather than redundancy, defining the conditions for choosing which employees will be made redundant and how conditions will be applied. For example, will it be appropriate to choose people from across the whole organization or from a particular department? Arrangements for travel, removal, related expenses where the employee, say, accepts work in a different place if the company is a multinational company and that option is available. Whether the redundant employee may leave during the notice period or postpone the date of the end of the notice without losing any entitlement to a redundancy payment. And Madam Speaker, whether an employee can keep any company benefits, say, when they're made redundant. These are some of the considerations, Madam Speaker, that will need to be had in respect of determining appropriate reporting protocols with respect to redundancy. Madam Speaker, employers need to show that in choosing a particular employee or particular employees, they had compared him or her in relation to the agreed selection criteria with those others who might have been made redundant, and that as a result, the employee was fairly selected. Madam Speaker, I would argue that consideration also needs to be given whether a claim for unfair dismissal may also arrive where an employer has failed to undertake a reasonable search for alternative work throughout the organization prior to dismissal. And Madam Speaker, this proposal ties in directly with what we're trying to achieve with respect to retooling and reskilling our people. If a position is being made redundant and there is another appropriate position or a position in which the person that's being made redundant could possibly fill with some level of training, with some level of support, especially if that position is currently held by a work permit holder. And as the law clearly states, there is no right to assume renewal of work permits pursuant to the law unless there is a prescribed term associated with that permit. Madam Speaker, this is the kind of thing that we are expecting employers to do when it comes to making a determination whether or not it is absolutely critical to make the employees, and in this case in particular Caymanian employees, redundant in this market. So, Madam Speaker, in accepting this motion to consider this matter, I am pleased to say that the government will attempt to effectively develop and capture the enabling provisions to implement appropriate procedures to help to operationalize the legislative requirements relating to redundancy in the draft bill to amend the labor law to be produced, hopefully, in short order. Madam Speaker, with respect to the issue of unfair dismissal, again, the preamble of this motion seems to focus in primarily on unfair dismissal as it relates to redundancy. But, Madam Speaker, I am here to state that the government will be bringing forward amendments to the unfair dismissal regime more broadly. So issues of unfair dismissal as it relates to unfair dismissal in general, also to constructive dismissal, including for issues of discrimination, victimization, harassment. The compensation for these type of unfair dismissals will also be enhanced in the draft bill. And so, whereas the motion is primarily concerned with redundancy, given the experience that the member has outlined in his presentation, the ministry intends to propose a healthy increase in the severance benefit as well as that for unfair dismissal where applicable, but of course, Madam Speaker, other than in cases than for cause or fair terminations for performance or misconduct related issues. And again, Madam Speaker, for information of the honourable members of this House and the general public, here is the excerpt of Section 55, 1 to 3 of the Labour Law dealing with remedies for unfair dismissal. 55.1 states that where upon a complaint of unfair dismissal, the Labour Tribunal has determined that the dismissal was unfair, it may order the payment by the employer to the person dismissed of a sum of money by way of compensation for unfair dismissal. 55.2 states that in making an award of compensation under subsection 1, a labor tribunal shall have regard to the length of the continuous employment of the person dismissed immediately preceding the dismissal, the likelihood of the person dismissed finding other comparable employment, the salary of the person dismissed immediately preceding the dismissal, the period up to the likely retirement age of the person dismissed and the entitlement to a pension which he may then have, the degree of unfairness of the dismissal, and such other matters as may be prescribed. Subsection 3 states that an amount of award of compensation under subsection 1, that is, unfair dismissal, shall not exceed 1 week's wages for each completed year of service. Madam Speaker, I am confident that the honourable members in this House will agree that while the considerations made in subsection 2 of 55 of section 65 of the Labour Law in making the award of compensation for unfair dismissal, the factors to consider, those are solid, those are reasonable. But, Madam Speaker, the actual compensation awarded in subsection 3 being restricted to 1 week's wages for each completed year of service is woefully inadequate. Madam Speaker, this is hardly a deterrent to powerful employers with deep pockets and or employers with ulterior motives. And it is also a pittance for an employee who has been dismissed unfairly, and that is the key, Madam Speaker. It is with respect to unfair dismissal. And for that employee to have to now seek new employment to rebuild his or her career after potentially being tarnished or ostracized in a small community such as this as a result of unfair dismissal. So, Madam Speaker, even though the motion calls for a consideration for calculation to be determined at the employer's latest basic wage at the day of dismissal, as a further means of strengthening the compensation for unfair dismissal, Madam Speaker, the Ministry and the Department are of the view that the law should be further improved by replacing the words latest basic wage to the highest average annual basic wage during employment with that employer. And Madam Speaker, this is an important improvement, and it is also timely due to the changing employee demographics, as well as taking into account the wage seasonality of some jobs and professions or employment sectors. For example, Madam Speaker, some people working in the hotel and tourism industry, they may be working quote-unquote full-time hours for part of the year and part-time hours for the other part of the year. So this change, this proposed change, which of course would need to be approved by all members in the House for the law to become law, this change would mean that any employee working in industries such as that would not necessarily be given their dismissal at the rate of their latest basic wage if they were on a part-time employment for that particular period of time. It is the highest average annual basic wage during the employment with that employer. That is a proposal, Madam Speaker, and one which will have will need a further discussion of the government in this instance. Madam Speaker, therefore, in accepting this motion to consider increasing the amount of award for unfair dismissal for up to 3 years' wages, consideration will be given to what is proposed by the movers, and the government will be bringing enhancement to the law in due course, in accordance with the ongoing review and fine-tuning of the draft bill to be brought forward for consideration by Cabinet. Madam Speaker, as I said, the motion asks for the government to consider, and that's exactly what I have demonstrated on behalf of the government, is that we are able to consider and we will be bringing changes to these specific provisions, because this is not only in line with the mover's vision, but also the government's vision for what needs to happen in order to protect vulnerable employees in these instances. So, Madam Speaker, the compensation for unfair dismissal, which is enshrined in the Labor Law 2011 revision, being 1 week for each year of service, is the same benefit which was prescribed in the Labor Law in 1987. So too in 2014, 27 years later. Madam Speaker, the last comprehensive review of the Labor Law, which culminated in the Employment Law 2004, it's interesting to note that compensation was not proposed to be increased there either. However, in connection with this matter specifically, the only improvement made in the Employment Law 2004 was with respect to including constructive dismissal and its definitions. But unfortunately, there was no applications or sanctions accordingly. So, Madam Speaker, the member was right in his analysis about there being only a few substantial amendments brought to the Labor Law since 1987 in this regard. So in conclusion, Madam Speaker, the government agrees with the honourable members who brought this motion that the current penalties and compensation award provisions in the Labor Law are inadequate, and they do not serve as a deterrent, and also the provisions can be manipulated by shrewd employers or their legal advisors. Madam Speaker, we, the government, we too are deeply concerned about this unsavory practice. We know there are many employers who abide by the law, many employers who go above and beyond the law, especially given that we recognize the legislation in this area is quite weak. So by bringing these amendments, we are in no way castigating carte blanche all employers, but we are saying for those employers, and you know who you are, if you are not abiding by the laws currently, I am here to put you on notice on behalf of the government that there will be stricter legislative regime to ensure that people, employees, Caymanian employees in particular with respect to redundancy, and employees in general as it in relation to unfair dismissal, that there will be strengthened protections to ensure that people can feel that once they do the job that they were hired to do, and that they don't have issues of disciplinary and other concerns, that they should be afforded some level of protection with respect to their compensation, their ability to remain on the job, etc. So, Madam Speaker, I give this House the commitment that the government will look to address these issues in the impending amendments. And we will also turn our attention to creating or improving the operational and institutional systems to properly administer and enforce the law in these other important and other important areas, which we've already begun to do with respect to the work of the Department of Commerce and Investment, the Department of Labor and Pensions, the NWDA, and Immigration as it relates to trade and business licenses and other areas of regulatory compliance, health insurance, etc. So, Madam Speaker, here is another example where this House is, in fact, united in our concern about unfair treatment, the unfair treatment of our people who are hardworking, who are determined to succeed, but in some instances are treated in a most unsavory and untenable fashion. And as a legislature, it is clear that we are determined to do something about these abuses which we know exist in the market today. And Madam Speaker, I would like to publicly accept the member from East End's invitation to work on moving this process forward, in that I would be happy to get the research that he's done on this matter. I would be happy to sit down with the member to discuss his concerns, and any other member for that matter, to review the proposals and to ensure that the at least due consideration is given to the concerns that is aired to, as he said, to all of us in this House in one form or another. Because in this instance, Madam Speaker, united we stand, and as a people, divided we will fall. And so I congratulate the movers for bringing this motion, and as a government, we are determined that we will act to deal with the issues and the mischief that this motion seeks to address. Thank you.
Does any other member wish to speak? Does any other member wish to speak? Final call. Does any other member wish to speak? Member from North Side.
Thank you, Madam Speaker. Just to thank the government for accepting the motion on to amend the labor law, and just to add one other item so that I believe the government could consider when they're looking at the labor law. One of the reasons that employers often give to people like us when we ask them why they're making Caymanians redundant and keeping on people on work permits is because of the amount of money that they have invested in the permit. And under the current immigration law, I think you can only get refunds if the person has worked for less than 6 months. And once you work 1 day over 6 months, you don't get anything. So it might be a carrot to say to them that we prorate the work permit fee over a 12-month period, so that even if they put somebody off in the 10th month, they'll get 1/12 of the fee back. So that because they're going to find every excuse in the world not to comply with the law willingly. But I certainly believe, Madam Speaker, that many Caymanian workers can be comforted tonight by the position taken by the government. And I am also confident that there are going to be several employers who are going to be worried that the government is prepared at long last. Because, Madam Speaker, I was here, and as one of the, not architects of the law, but certainly one of those who advocated to bring about the labor law in the 80s. At that time, people like myself knew that the rewards for unfair dismissal were very low, but unfortunately, at the time, those are many of the compromises that the government had to strike with particularly the business people and employers in order to get any labor legislation in the books at all. So, Madam Speaker, once again, I thank the government, and I also am willing to work in any way that I can to help bring this. And I would just also say to the government that having warned them, we don't want to wait too long before we bring the actual law, because there are also going to be those who, when they hear that the government is about to do something constructive, are going to be deliberately looking to get rid of those before the law comes into force. And we don't want to give them too long a period of time to do that. So thank you, Madam Speaker.
Does any other member wish to speak? Recognize the fifth elected member from the District of Georgetown.
Thank you, Madam Speaker. I rise to give my support to the motion brought by the member from East End. Madam Speaker, I listened to both the proposer of the motion and the Minister of Employment, and there were common themes in each of their statements. Madam Speaker, we have to remember at all times why we're doing what we do, why we gave up a lot of family time, a lot of other precious time that we could be doing other things. It is love of country and love for our own people. And when we see those people, Madam Speaker, being abused, and it's at every single level, Madam Speaker, from the bottom to the top, and being done with impunity, it's our role, it's our responsibility, it's what we were elected to cure. Madam Speaker, I can't add much more to what was said, but I will say that I am 100% behind this motion, and I'm glad that the government that I'm a part of and all the members in this honorable House feel the same way. We are an inclusive people, Madam Speaker. We have always opened our borders with open arms. But at times, people, and I don't know if it's just because they're not used to being greeted with such friendliness, that they take that as a sign of weakness. Madam Speaker, there are no fools in this House. We see and we've experienced a lot of what we talk about. But Madam Speaker, and I will always say this, if we're not doing this for the good of Cayman and Caymanians first, then why are we doing any of it? Madam Speaker, with those few words, I just want to thank the member for bringing the motion, and he has 100% of my support. Thank you.
Does any other member wish to speak? I recognize the fourth elected member from the District of Bordentown.
Thank you, Madam Speaker. I will be equally brief. I just wanted to rise to give my support for this motion and to thank the member from East End for bringing it, and to also thank the minister for rising to accept the motion and committing to accept this motion and to do more of the same in the near future. I think it is timely. I think that this country needs this sort of attention at this point, and our people have been crying out for the government to step in and to fix something that has gone drastically wrong in this country. And I wish to thank all members of this House for supporting this motion. Thank you.
Does any other member wish to speak? Does any other member wish to speak or recognize the second elected member from the District of Georgetown?
Thank you too, Madam Speaker. Shall be equally as brief as my two previous colleagues, but to also say publicly that I'm fully supporting the motion that is before us. I believe, Madam Speaker, it's been an overhaul of our employment laws and labour practices have been long overdue. And this motion is timely, recognizing that a review of the labour law had already been underway. It's even more critical now that these things be incorporated, that as the Minister has so ably stated, they will be considered as part of the review that is ongoing. I'm looking forward to seeing the final product, to debating it and considering it and ultimately approving it. But I stand firmly with the member from East End and with the government bench on this in supporting the amendments and moving this forward to its conclusion. With those few words, I thank you, Madam Speaker.
Does any other member wish to speak? The Honourable Minister responsible for Finance.
Thank you, Madam Speaker. Madam Speaker, I too rise to give my support to the motion. The Honourable Minister for Labour already having accepted it on behalf of the government, but just to say that, as everyone else has said, it is timely, and I do believe that with the review of the legislation and successful passage in time to come, we would hopefully strike a happy medium between what is affordable by the employer and what is deserving on the part of the employee. And Madam Speaker, I don't think that anyone should fear being ridiculed by anyone else, because it appears that if you say nothing, you're ridiculed, so you might as well get up and try to do what's in the best interest of the working people. So, Madam Speaker, I'm thankful that this has come at this time, and we will do our best to ensure that it is brought to the floor of this honourable House for passage. Thank you.
Does any other member wish to speak? Does any other member wish to speak? Final call. Does any other member wish to speak? The third elected member from the District of Westby.
Madam Speaker, I too raise to congratulate the member from East End and the seconder from Northside on this timely bill. I want to thank the government and congratulate the government for accepting it. And I too, or us too on this side, we support it. My only wish for this bill that it will also extend to protect civil servants. For too long it has gone on, what has gone on in the private sector, they're held to one standard and a different standard has gone on in government. Let us hope that this will protect civil servants as well. Thank you very much.
Does any other member wish to speak? Does any other member wish to speak? Last call. Does any other member wish to speak? If not, I'll call on a member from Easton to exercise his right of reply.
Thank you, Madam Speaker. Madam Speaker, I know when to hold them, when to fold them, and I know when to be graceful in victory. I don't know so much about defeat, but I know when to be graceful. Madam Speaker, I want to thank the government in particular and all honorable members for recognizing that this motion is timely, but importantly, the contents therein, how they're needed in a otherwise country that is wanting, is needing, is in need of help. The minister, in accepting this motion, said that there may be things different from the way I asked. Well, I guess I said that at the beginning, now that I did some research since the motion has been in, which I usually do before, but I don't know what caught me up. And she talked about highest average annual basic wage during employment, I think, something like that. I'm perfectly fine with all that. Just bring it. It's you know, Madam Speaker, it's always good when we work together on these issues, contrary to public opinion that we don't know how to work together. I believe it can be said when there are issues of such importance that this country comes together regardless. On the 11th, we stood in here and talked about how much we work together after Ivan. If you want to see Caymanians work together, create adversity. So I'm happy to work with the government, with the minister, and I invite her to look at that Turks and Caicos. It is quite instructive. You know, Madam Speaker, having said that, and it's not usual you hear veteran legislators say this, but I must say that these young Turks, these rookies, are coming into their own. And I want to extend that by saying 14 years is not something you shake a stick at. 14 years of contribution to my country, and it will be 16 at the next general election. And I'm feeling quite confident that I can fade into the sunset if these continue to come as fast as they are coming. I am fairly confident in that, you know, if it's necessary for me to fade into the sunset, no legislature changes all of its people in one fell swoop. And there are enough here that we just need to get them a little further along the way. And the fifth elected member said a while ago that there aren't any fools in here. And that's true. We're seeing that manifest itself on a daily basis. But those of us who have been here for so long are getting ready to fade into the sunset. So I know you want to stay here forever. Huh. But there will be time for all of us to understand that we are not fixtures in this house, and we are but for a time, and this real estate belongs to someone else. We operate it, we occupy it, but for a time. And these are coming. Young, only young, Madam Speaker, in the sense of how long they have been in here, you know. I commit myself to being an older than them. Okay. So, Madam Speaker, let me thank the government again, and I look forward to it. I look forward to it. The introduction and of an amending bill here to look at this labor law. We need to do something about it. We need to ensure that our people are protected, which they're not right now. So, Madam Speaker, once again, I believe this must be the last thing on the order of paper, so let me say goodbye to everybody. I don't know when we will be back, but I trust that it won't be very long. Hopefully we can bring the labor law back by then, but that's pushing it, the minister says. Madam Speaker, again, thank you very much too for your indulgence, and I look forward to working with the government, whether that be through minister committees or whatever, to get this thing done as quickly as possible.
The question is, be it therefore resolved that the government consider amending the labor law to require employers who claim downsizing through redundancy of Caymanian employees where foreign work permit holders are employed to prove such redundancy to the Labor Department and notify the relevant immigration boards. And be it further resolved that the government consider increasing the amount of award by a labor tribunal for unfair dismissal to an amount equal to up to 3 years' wages at the employee's latest basic wage at the date of dismissal. All those in favor, please say aye. Aye. Those against, no. The ayes have it. Accordingly, motion 10, 2014, 2015 is hereby passed. Recognize the Honorable Just before calling on Honorable Premier, I wonder if the first elected member from Bodden Town still wish to say a word.
Thank you, Madam Speaker. It almost slipped my mind, and I appreciate you reminding me. This was just to acknowledge and extend sympathies to the family of the late Hubert Bodden, who passed away on the 4th of September, to his wife, Liz, son Barry, and his wife, Karen, Cindy Kay, his daughter, his brothers Abshire, Sammy, and Gerald. We all remember how he was a great son of the soil, believed in doing so many things within the community. And I always remember the effort that he put on Newlands Road, where they kept that immaculate, he and his brother Jay. And I know that on behalf of you, Madam Speaker, and all of my colleagues in the Legislative Assembly, would like to indicate a great appreciation for the efforts he's put into beautifying Cayman and to sympathize with the family. Thank you, Madam Speaker, and have a good evening.
Honorable Premier.
Thank you, Madam Speaker. The Lord giveth and the Lord taketh. Blessed be the name of the Lord. Madam Speaker, this has been, I think, one of the most productive meetings of the Legislative Assembly that I have had the good fortune to be part of. And I want to thank all members for the way that they have gone about the task. All of the motions were not easy, and all of the motions were not unanimous, or the position was not unanimous, but members have conducted themselves, I think, in the best possible way and with the greatest statesmanship that one could ask for. And I want to convey to all members my thanks and my pride in their conduct and the work of this Legislative Assembly, this meeting. I want to thank you, Madam Speaker, and the staff of the Legislative Assembly for working late every evening since we've been here. But it's meant that we've gotten through 3 government bills. I've forgotten how many questions, 5 or 6 statements, and 10 private members' motions in 5 days. That's a pretty good record. I want to thank everyone again for their hard work. And I move the adjournment of this Honorable House, sine die.
The question is that this Honorable House be now adjourned, sine die. All those in favor, please say aye. Aye. Those against, no. The ayes have it. Accordingly, the House is now stands adjourned, sine die.